May it please the Court, Paul Hudson on behalf of the respondents. And, Your Honor, I'd like to reserve 2 minutes for rebuttal.
So be it.
Your Honors, the question in this case is whether a lawyer can inherit under a will he prepared in violation of the Michigan rules of professional conduct. We submit that the answer to that question is no. And the big picture reason is that courts should play no role in helping a lawyer profit from his ethical misconduct. And certainly the court should play no role in incentivizing that behavior. The more specific reason is that when a lawyer violates an ethics rule, the result is that the offending provisions that he prepared are simply always void as a matter of law as against public policy every time. And so when the petitioner here violated Rule 1.8c, the offending gifts to himself and his children, the $16 million gifts, were simply void right from the start. The moment his pen hit the paper, so to speak, it's as if they never happened. They're a legal nullity. And that highlights the central flaw in the petitioner's position here. Courts can't enforce void provisions, and so the petitioner has come to the court with no legally valid expression of the decedent's testamentary intent to leave him this money. And so where does the money go? Well, the decedent built in contingency clauses that provided that if any provision of his will or trust failed, that he wanted his money to go to his heirs, the respondents here. And so that's what we ask the court to enforce, the only legally valid expression of the decedent's testamentary intent that we have in this case or that we'll ever have. The court directed us to address whether in re power stands in the way of that holding, and if so, whether it should be overruled. We think that the best view of the law is that the court already, in enacting Rule 1.8c, superseded and displaced powers. Under the powers regime, it was not a bright line rule. There were some circumstances that lawyers could do this.
Counsel?
Yes, Your Honor.
This will, had it not been prepared by a lawyer who was a beneficiary, would not be void, correct?
That is correct.
So the only artifact that creates a question as to its viability is the participation of the lawyer who is a beneficiary.
Yes, Your Honor.
Here's my concern. That being the case, the legislature has created the means by which to contest wills. MCL 73407C states that a contestant of a will has the burden of establishing the lack of testamentary intent or capacity, undue influence, fraud, duress, mistake, or revocation. In addition, 700.7406 states, quote, a trust is void to the extent that its creation was induced by fraud, duress, or undue influence. Now, it strikes me that the legislature, which is the entity that makes our positive law, has created the means by which to contest a will. And contrasting with this court's constitutional and statutory authority to prescribe ethics for the profession is not to create substantive positive law. And so I'm trying to figure out why, especially since our canons say they don't create causes of action, our canon gets to trump the methodology that the legislature has created for contesting a will.
Your Honor, step one in any will or trust proceeding is, okay, where is the legal document that expresses the decedent's testamentary intent? So the legislature certainly created mechanisms for challenging based on undue influence. The legislature also created the ways that a valid will or trust is created. And one of those, for example, is MCL 700.7404. A trust may be created only to the extent that it's not contrary to public policy. And this court has said that we, of course, want to honor a decedent's testamentary intent, but only insofar as it's expressed in a valid testamentary instrument.
But you're using the canon to, at the initial stage, say it can't even be contested.
That's correct. That because there is a violation of an ethics rule, step one, and I think that's undisputed here, The result of that is that it violates Michigan public policy. That comes from this court's decisions.
The public policy of our canons, our ethical canons, is limited to the regulation of the practice, not the substantive law of wills and trusts. And the rules themselves say they don't create causes of action. It's strictly for regulation of the profession.
It's certainly true that,
So
it's a rule of practice
You're elevating
and not a rule of
practice
substance.
concern to a substantive rule of policy that would trump the methodology that the legislature has created in these two statutes for challenging wills and trusts.
Your Honor, the argument is premised on, it's two premises. Number one, if a lawyer violates a rule of professional conduct, that's a violation of public policy.
Attorney Grievance Commission.
And step two is if a provision in a legal document violates public policy, then it's void as a matter of law.
We started out saying the purpose of this will and trust was not illegal or void, but for the involvement of the lawyer who wrote it, who was a beneficiary, correct?
That's correct, yes.
So
and it would have been very easy.
The purpose of this will is not illegal. It is not void otherwise, but for the involvement of the lawyer who's a beneficiary.
That is correct, and it would have been very easy if this was indeed the testamentary intent of the decedent to honor that testamentary intent by walking the client to another lawyer or another law firm. It's the lawyer's job to make sure there's a legally enforceable, valid expression of this testamentary intent. He's charged with that duty.
I think I understand your argument.
And in a sense, this is sort of like he violated his professional standards in effectuating the testator's intent, and he's the one that has to suffer the consequences of that.
Well, what about the testator? If this were a valid expression of the testator's intentions, your remedy, in fact, unseats those intentions, does it not?
Step one, before anything else, is there has to be a valid will and a valid trust, validly expressing his testamentary intent. For centuries, there have been.
Tell you how to challenge that.
The legislature is telling us how the will is validly created as well, and if the lawyer is violating an ethics rule.
Where does it tell us how it's validly created?
MCL 700.7404 for a trust and 2705 for wills. The trust may be created only to the extent it's not contrary to public policy.
Yeah, but the will is not.
Does it matter that it doesn't say that there's not the same language for wills as there are for trusts with respect to the public policy piece?
There's the same language in the will section 2705 that it can only be created to the extent its purposes do not violate public policy.
Its purposes. That's what you elide. The purpose of this will is not illegal.
The purpose
under any stretch. There is no public policy violation of the purpose of this will. It's not designed to discriminate or all the things that you cannot write a will to. The purpose, we started out with, my question was, this is not an illegal will, and its contents do not violate public policy, correct?
To accept that argument, you have to believe that when a lawyer violates a rule of professional conduct in drafting and preparing a legal document, that those provisions are not void. Ab initio as a matter of law.
You read me two provisions that said that you couldn't create a will or trust for a purpose that violated public policy. This will's purpose does not violate a public policy. Its creation may violate a canon, ethical canon, but the purpose is not at issue, correct?
I think that's a very narrow reading of purpose. The purpose here is to pass this $16 million.
What is the purpose of the will?
The purpose of the will is to, well, according to the petitioner, is to
just as a general matter, what is the purpose of a will?
To dispose of a decedent's property at death.
Now, a purpose that violates public policy would mean a will that was designed to do something in its framework,
and
not its creation, right? Isn't there a difference there?
And the purpose of this will is to dispose of this property to an unethical lawyer who prepared a will in violation of the rules of professional conduct. And I
Let me
think
ask
that's-
you a
Yes, ma'am.
hypothetical. So let's say we have a lawyer who's been suspended from the practice of law. And during that, let's say it's a 6-month suspension, the lawyer drafts a contract on behalf, takes a client, lawyer's not supposed to, but does, and drafts a contract on behalf of that client, and the contract is otherwise valid. There's a meeting of the minds, mutually advantageous exchange, consideration, awesome contract, parties happy with contract. And then the one party goes to enforce the contract and says, oh wait, I don't have to fulfill my contractual obligations because the lawyer, I don't care whose lawyer it was not authorized to practice law. The lawyer was behaving unethically. Is the contract void? Or is the lawyer just subject to bar discipline?
The Court of Appeals has addressed that, and I think absolutely correctly, in a series of cases, Evans and Luptak, Morris and Doherty. And it's the same situation where there is all the contractual requirements are met, the meeting of the minds, everything else.
Excuse me. Hers is a very different hypothetical than those cases where the lawyers were actual parties to those illegal contracts.
Right.
She's got a circumstance in which the contracting parties do not include the lawyer who's unauthorized to practice law, but are now interposing the fact that it was drafted by a person not authorized to practice by law, that it is void.
And so, well, if I'm understanding the hypothetical correctly, I mean, there's no requirement that two contracting parties go through a lawyer to draft this contract.
There's no requirement that I go through a lawyer to draft my own will.
No, that's right. But it's the lawyer that's trying to benefit from the unethical provision. I think that's the key, is that the courts can't sort of aid the lawyer in benefiting from his unethical and wrongful conduct.
What if the lawyer owned a small piece of stock in the corporation that was ultimately going to benefit from the contract? But the lawyer's not authorized to practice law during that period of time.
Yeah, I think...
So now the contract is void?
To the extent that the lawyer violated the rules of professional conduct in drafting the provisions of that contract, the provisions that violate the ethical rules are void, not the contract as a whole.
Well, you have a different rule when it's a will, though, right? The
No.
whole thing is void, not the proviso to the...
And to be clear, Your Honor, that's not our position here. Our position is that it's a 61-page trust and a several-page will, and the will as a whole stands, the trust as a whole stands, and it's the specific provisions that the lawyer prepared in violation of the rules of professional conduct that are void.
So is the contract, if the lawyer benefits from the contract he drafted for two parties while unlicensed, is the contract void in part?
It's void to the extent the provision benefits the lawyer, right?
What if the deal is, like, I'm going to sell you my company. So company A says, I'm going to sell you company B. And then turns out the lawyer owns a little piece of company B. This sale can't go through. So everybody else who owns a share of that company is out because this lawyer violated an ethical prohibition?
The piece of that is void that benefits the
piece?
lawyer
The
to
sale?
the extent there's a violation of the ethics.
The sale
The sale.
is void.
Yes.
The purpose of the contract is void then because of the ownership.
Because of the lawyer's malpractice, and the remedy for the rest of the people in the contract is a malpractice action against this lawyer for his failure to properly dispose of his duties in drafting the contract.
What do you make of the fact that the legislature has an express non-suit for a subscriber to a will or trust? If you subscribe as a witness to a will or trust and are a beneficiary, whether you know it or not, you can't take. There's no similar express prohibition for a lawyer who is a beneficiary, although there are states that have such provision. What should we make of that fact in this context?
I think the fact here is that this court, in enacting Rule 1.8c, drew a bright line rule here that says a lawyer shall not do this under any circumstances, no, not waivable, can never do this. And the necessary consequence of that, I think, the implicit consequence of that,
is a trip to the AGC?
Is not just a trip to the Attorney Grievance Commission, but that you can't profit from your violation of that. It's sort of like the bank robber who says, well, there's a statute that says I can't rob a bank and you can send me to jail, but it doesn't say anything about what happens to the money I robbed. Or a check forger who prepares if there's a statute that says you shall not prepare a forged check, and the guy prepares a forged check and says, yeah, you got me and send me to jail, but doesn't say I can't keep the money. That's essentially the argument here. So I think it's implicit in Rule 1.8c that this court was disposing of the old regime where a lawyer, it was sort of dismal professional ethics, as the court put it in Powers, but it was not a bright line rule. And when the court stepped in 1988 and said, you shall not do this anymore, that's the new regime, and implicit in that, the text of that rule is that the lawyer can't recover anymore.
One more question. When the legislature arguably abrogates common law rule, we require a very bright line statement from the legislature. This common law rule is hereby abrogated is basically what this court. So why do you think a rule of professional responsibility would be held to a lesser standard?
Well, I think, number one, it was very clear that there did not used to be a common law rule that a lawyer absolutely shall not do this. And when the rule now says you absolutely shall.
It says you can't draft, but it doesn't say you can't take under the will.
Yeah, and I think that's sort of implicit. And the flip side of that is, the court shouldn't have to wait around 30 years for a lawyer to violate that rule, for the case to work its way all the way up through the lower courts. And this rule just sort of lays dormant for 30 years until this court overrules all of the prior decisions before the rule. Because if that were the case, then when the court is exercising its constitutional rulemaking powers, then sort of the rule comes out, and then the scramble is on to sort of find old cases, and you can violate the rule until this court
No, you can't.
expressly.
You're subject to discipline of the Attorney Grievance Commission.
Right, and I think this case sort of highlights the danger of relying on that entirely, because if the stakes are high enough and you're close enough to retirement, unscrupulous lawyers perhaps might say, you know what, I'm gonna roll the dice on this, and undue influence presumption doesn't have all that much teeth to it.
At the end of your practice, you should find some really wealthy clients and get really close to them.
That's exactly the incentive.
That's the message.
That's exactly the message, exactly the incentive that it's providing. And so far, I think the absolute shall not rule has worked pretty effectively since 1988. I don't think there's been any cases that have been upheld in these courts.
Counsel, that leads me to this follow-up question. I know this case is still pending, but what is the usual sanction by the AGC for attorneys who do this?
From what I understand, and this, it's been reprimand, not even disbarment, and the AGC certainly doesn't have the power to sort of disgorge the fruits of the ethical violation. And so the incentive will be there, make no mistake, to
like Justice
violate.
McCormick was saying, so basically, as an attorney, I'm looking at this kind of a more simplistic basis, but the idea being, if I'm an attorney, I go and I participate in this, I become part of a will, and then ultimately I'm going to be subject to a reprimand by the AGC.
Just make sure you step down from the bench, Richard.
Yeah, exactly.
I'm going to step down and write his will.
Exactly. So, but that's really the essence of it. So you get a reprimand from the AGC, and then ultimately you would keep the proceeds?
Yeah, you go down to the beach. Yeah, I think that is the position that the petitioner is advocating. That's the regime that the court would be ushering in if we turn this shall not into a shall not unless you don't unduly influence the guy.
Counsel, is it your position that the change in 1988 was sufficient to reverse Powers?
Yes, and I think that's the best view of the law.
Powers has been abrogated by an ethics rule? I mean,
Yes.
That seems like a strange position to take.
It seems strange unless
I
you,
mean, has that ever happened before? Has the court ever said, we had an ethics rule change and then therefore that overturned Supreme Court binding precedent?
conceptually, it's no different than if the legislature had stepped in 1988
Except that
and
if
done
the
the same
legislature
thing.
had stepped in, we would require them, in order to abrogate the common law, to say, basically, we hereby abrogate the common law rule. Like, it must be in no explicit terms, or,
And I think it's pretty clear here, but
Why, let me ask a different question. Isn't there a tension between, the thing that I think you're putting your pulse on from the practice of law standpoint, but I'm looking at from the court standpoint, we're responsible both for the rules of ethics and for the common law development, evidentiary presumption and powers. And isn't there a tension between the two where we say in an ethics rule, you shall not do this, flat prohibition, and then we sort of speak out of the other side of our mouth by saying, but if you do so, here's the roadmap to getting away with it, by saying, here's how you walk through and can overcome this presumption. Isn't that, from our standpoint, not from the practitioner standpoint, but isn't that a problem?
I think it's two parts. Number one, it's this court, in exercising its rulemaking authority, is wearing its legislative hat, its permissible legislative hat, not legislating from the bench in that sense, but it has the full force of the statute.
I understand your position. We wouldn't be having this conversation if I couldn't get down the road far enough to say that it's possible that our ethics rule are an expression of public policy, like we've said in Tarion, and I think I've recognized in other places.
And the part that's not infringing one bit on the legislature's authority on the substantive law part of this is the legislature has said in 700.7410 that a trust terminates to the extent, quote, the purposes of the trust are found by a court to be unlawful or contrary to public policy. So the legislature expressly envisions that it's going to be the court that's making determinations of public policy here. So if the court determines that it's an invalid purpose for a lawyer to violate a clear ethics rule and still profit $16 million, then the legislature has said that's the court's determination to make. The court can invalidate that trust provision.
but is there a similar rule for wills as opposed to trusts? I think that's the question Justice McCormick asked you.
Not that
earlier.
Specific one for trust, not the if purposes of the trust are found by. There is the will may be created only to the extent its purposes are not contrary to public policy. So both parts of those are there.
Where does it say that, just so we're clear?
We have 700.7410 is purposes of the trust are found by the court to be contrary to public policy.
I'm with you. 7410 and 7404
Then we have
speak to trust.
700404 for trust may be created only to the extent the trust may be
Where
created
does
only.
it say that for wills?
2705.
Isn't that a choice of law provision?
It's a sort of strange provision, but it's essentially saying
not as helpful for you as the other two, right?
not as helpful. But to be clear here, the real operative term here is in the trust. That's where these dispositions, because all the will says essentially there's public or personal property going to him in the will, but then the residual estate pours over into this trust. So it's the trust provisions that are disposing of these $16 million in assets. And so if the court finds that those purposes are contrary to public policy, then it clearly has authority under 7410 to invalidate those
But then is the
provisions.
argument that did the lawyer set up the trust as well?
The lawyer set up the trust as well, yes.
Yeah.
But is there any,
Prepared the trust.
and you think setting up the trust alone was a violation of the ethics rule too?
Yes. The 1.8C does not only apply to trusts, it applies
It
to
applies to trusts.
any instrument.
Any instrument.
But if you're asking us to rely on 7404 and 7410, which are more explicitly in relation to the public policy argument, would it make any sense for us to come up with a rule that treats wills one way and trusts a different way when it comes to this?
No, I don't think so. And I think the same analysis applies to the will.
It would just incentivize lawyers to write it up one way instead of another way.
Right, just have the-
I'm just trying to figure out how I can
have the
dispose of
will be-
Justice Bernstein's assets.
I claimed him
No, I'm staying closer to it.
No, no.
I got it.
Right, have your will one paragraph and just say it's the trust. So to be clear, I think our argument works for both trusts and wills.
Would there be any interest in hearing from the other side at this point?
Yeah, maybe.
Okay, thank you, Mr. Hines. We
Whatever
appreciate it.
idea that is.
Good afternoon, Mr. Chief Justice. May it please the Court. David Garcia, appearing on behalf of the appellee, Mr. Mark Papazian. I'm going to abandon a little bit some of what I planned on doing and kind of jump right in, if I can, to some of the questions that have been floated around this morning, because I think there's a few things in play here. Number one is there are at least twin issues that are bouncing around the courtroom today, and probably more than two. But to stick with two for a moment, the one that I've probably heard the most about in the Court's questioning today is the issue of whether we should or whether there are problems with elevating the rules of professional conduct to the level of substantive law, particularly where you have an existing statutory scheme. And a lot of those statutory provisions have already been mentioned this morning. But tied to that was a question or a back and forth between Justices McCormick and Justice Bernstein. And the conversation, I'm grossly paraphrasing, was basically, look, all that's going to happen here is a slap on the wrist for a lawyer, and isn't there every incentive in the world for fostering bad behavior? And I want to point out one thing we cited in our brief, because I fear that with the back and forth with Brother Counsel this morning, the Court will be left with a very bad misconception. We cited to, and I'm referring to page 24 of our MOA brief, footnote 53, a couple of grievance proceedings. And I think that's what counsel was referring to when he said, oh, there was just a reprimand or a suspension or not terribly significant proceedings. There's a reason for that in those particular cases, and the reason was that the grievance committee, as they should have done, looked at what's the purpose for Rule 1.8. The purpose, according to the ABA who drafted the original rule, is a rule about undue influence. And so the grievance commission looked in the case of matter of Robert Watson, the one I was referring to, and they said in this case, this wasn't someone who sidled up to an elderly person late in their life and conned them into giving away money.
Here's the question, though, and
Yes.
I think this is really the question, is, and help me to understand that. Now, I realize that we have powers, and I realize there's a stare decisis argument that is always a very powerful and respectable argument that this Court adheres to as it pertains to powers. But this is the issue. Help me to understand why it isn't the case that you simply, and granted, we're moving past powers and the stare decisis argument, but I just want to understand from you, why is there not a red line rule that just simply says, if a lawyer participates in an action where they're going to inherit from a will or a trust or whatever the instrument in question is, that it's no longer valid? It's quick, it's red line, it's easy to understand, you understand what the penalty is, you understand what the sanction is. It makes it very easy to kind of appreciate what happens if someone were to do that. And me, as the person that is going in and creating this will, realize, you need to know that this is what's going to happen. I mean, you have a simple red line rule. If you inherit, it's no longer an effective instrument.
And I think the simple, straightforward answer to that is because such a rule would be completely offensive to the top priority of all of probate law, which is to honor the testamentary intent of the person making the will, who doesn't know what the rules of conduct are. We have particular facts in this case. I won't even bother going into them. But that he actually became aware late in his life that there might be some kind of issue here. He didn't care. He knew what his will said. He was advised by people.
But what if I don't notarize it? What if I don't date it? What if I don't do a set of
Excellent.
other things that I'm supposed to do? Wouldn't that kind of go against your argument? If I don't do certain other components to that, then I still run into the same problem.
But there are, actually, I think that goes the other way, Justice, because there are actual provisions. For example, just to pick one, a holographic will. There are provisions in probate law that make clear and I think articulate a overarching policy favoritism in favor of the testator, that if you don't comply with the statute, if there are issues with, well, you don't have a witness, you don't have it signed properly, you don't have it executed properly, we will overlook those things, because the North Star for us, that's the language from the cases, is getting to testator intent. And as long as we can free ourselves of issues like undue influence, fraud, duress, and others, issues with execution, if we can get there, we'll uphold testator intent.
No, and I totally appreciate that. I'm just trying to understand. Is there anything that knocks a will out, or is there anything that, I understand that we're going to testator intent, those kinds of things. Is there anything that you can do to this instrument that makes it null and void, period? Just, you do this, and you don't have a valid document.
Is there, I'm not trying to joust at all, is there anything like completely out of the context of this case?
Yes, yeah. I just, I'm going back to my estates and trust class. I'm just trying to remember. Is there anything that I can do?
I'm going back to mine, too.
Right. Is there anything that you can do to a document that would make it not a valid document?
Yeah, you can make it for an illegal or a purpose. You can say, this is for the white children playground. And the purpose of that would be a violation of positive law and public policy.
Yeah, I suppose it's sort of the reverse. It's not only those things, and those cases have been cited in all the briefs, but there are already statutory broad reasons to throw out a will, throw out a trust, undue influence, fraud, duress, and others. So there are many things.
The question goes to, is there something in the creation that causes it to be void on its face?
And in the case of LaFond, which I believe is the case that Justice Young was referring to, that was the playground for all white children, violating public policy, therefore void.
Can I
Yes.
ask you a little bit about powers? So the ABA canon, code, ethical considerations, disciplinary rules, model rules, there's been this like evolution in the standards by which we judge the practice of law. There was, the canons that were adopted at the turn of the century were, I think, adopted by most states, and then in the 60s, the ABA moved to the code, which had canons and ethical considerations and disciplinary rules. Some of those were aspirational, some of them were more rule-like. And then in the late 70s, the ABA looked at it again, and finally in 83, we adopted these model rules. Powers is 65. It's like, a few iterations before the current version of the rules which Michigan adopted. Isn't it a little bit like citing Leviticus?
I don't think it is, and I'm glad you asked that. I don't think that the passage of Rule 1.8 is nearly the tectonic shift in law that the appellants are trying to make it sound like. Because, yes, everything that history you ran through of the changes in the rules is correct. But even look at Powers itself. And we can go back 100 years before Powers, too. But even look at Powers, because I think a fair reading of the case is not that the Powers court said, this behavior is just fine with us. There's nothing possibly unethical about this. They said, no. We're going to, A, look at these instruments with great suspicion, and we are going to institute or implement a presumption of undue influence.
And that makes sense, since at the time there was not a shall not in the rule, right? There was this aspirational, this is probably not a good idea. Well, now we have, don't do it.
I think Powers, I believe it's 2 or 3 years later in Carbadian, and I think there are even other cases into the 80s, and frankly, the first one I can recall we cite in our brief is 1897. And I get, Justice, your distinction between aspirational and mandatory, but I think this touches on a question from Justice Larson, and there's maybe an intersection here. It does say shall not, so it's not aspirational as of Rule 1.8. But what it doesn't complete is the sentence that the appellants need it to complete, respectfully, for them to win. Shall not, ... and if he or she does, the testamentary gift is void. That is what, respectfully, I think needs to come from the legislature, and it's why, and I will be the first to admit these cases are absolutely, of course, not binding, but the identical issue and why they've come up quickly in Connecticut, Pennsylvania, and I believe Florida. We cite all of them. This exact issue, the intersection between 1.8 and statutory probate policy, have all gone, in this case, would be in the favor of the appellee and in favor of upholding the Court of Appeals decision.
Not all of them. There's Texas precedent, isn't there, that goes the other way?
Frankly, I have not seen the Texas case. I'm not even sure if they have a statute that deals with this. But the three, and frankly the only three I was aware of, are the three that we cited here.
This argument about whether or not the rules of professional conduct can have substantive effect.
Mm-hmm.
Didn't our court already decide to the contrary in the Abrams order, where we adopted Judge Griffin's dissent, where he says that he's not persuaded by plaintiff's reliance on the provision, the very provision that we're discussing now, 1.0b, and its comment in the context there of the attorney, I believe the attorney fee contract. But isn't that already binding precedent? Isn't there? And I guess the follow-up question to that would be, then don't we already have conflicting precedent in Michigan on these various points?
I'm sorry, I thought I was following that question. And then
All right, well, go with the first one first. Aren't we stuck already? I mean, haven't we already rejected the notion that the rules can't have this kind of an impact?
To make sure I'm clear, there is case law about the rules formulating part of Michigan public policy. I don't quarrel with that. The question is really whether the rules, and I think this is something Justice Young articulated earlier, of whether the rules and the court through promulgation of the rules can create, or in this case I would say supplant, substantive law. And I think that question has also been answered as a no, particularly where you're not working. I think it's important to keep going
Where
back.
has it been answered as a no?
Bear with me for one moment.
How about McDougall versus Shot?
That's, I was just looking for it. It is the McDougall case, Your Honor. Yeah, and Justice Young wrote in that case, and this is a quote, "This court is not authorized to enact rules that establish, abrogate, or modify the substantive law." That's 1999.
Still good law.
In relation to the rules of professional conduct, or was that the court rules? What were we talking about there?
Substantive law.
It was in relation to the rules and substantive law.
But our rulemaking authority, I'm just trying to,
I think we're talking past each other a little bit. I mean, the substantive law, you don't dispute that the substantive law here is that if the trust violates public policy, we're supposed to avoid it, right?
If the purpose of a trust violates public policy, it can be voided. But the question is, and we've gone around this again too, is whether the drafting and the creation of a document is the same thing as an improper purpose, like in Lafon, a playground for only one type of child, which I think are totally different things, and not just on a semantic splitting hair level. It's because you're looking at what was the testator's intent, which is the entire point of the probate code. The testator's intent in Lafon was, frankly, racist. It was something that public policy should not permit. What was the testator's intent here, or in the next raft of cases that might follow this? To give money to a lifelong friend.
Except, Counsel, you said that at a certain point he became aware that this could be a problem in terms of the way that it was drafted, and he chose not to act, and he chose not to reform it or change it or do anything, even though he knew that this could be a problem. How do I read that? I mean, if he was aware that this could be a problem and chose not to act on it, isn't that a cause for concern? If I'm writing a will, or if I'm doing this and I realize, oh my God, I've done something that could make it void, and I do nothing, all he had to do in this situation was, contract another attorney and have this person written in. That's all that had to be done.
Well, and I realize the court may not want to go too far down the factual rabbit hole given the MOA issue, but to answer that specifically, so here's what he did: is he talked to another lawyer. He actually talked to a financial advisor and technically two lawyers who laid out his plan. Here's what it would do, and he was happy with it. So at the end of the day, the direct answer to your question is he really didn't have any reason to do anything else. He told a different lawyer, not Mr. Papazian, he was fine with his estate plan and he was signing off on it. He didn't want to make any changes. So that's the factual answer to your question, Justice. I only want to add one more item, and I see I'm running low on time, and that is what we're asking the court for. One is very obvious, and I won't spend much time on. That's obviously a reaffirmation of powers and essentially to embrace the Court of Appeals approach, in this case below.
Do we have to do anything other than deny to do that, then?
Well, and that's sort of the part B. I think you can accomplish essentially the same thing by denying, but also is something that this court did roughly about 6 months ago in the Greer case, which was, after hearing argument, denying an application for leave with what I will summarize as a note to the legislature of, there's a conclusion being reached here, and the legislature has not spoken on it. And this is the province that if the legislature doesn't like it, it should step in and act, because the role of the court should respectfully continue to be not to engraft rules upon the probate
An
code.
equivalent of the subscriber prohibition? Are you
Yes, what you said earlier with, for example, a witness not being able,
witness,
it's been done in other states. It's a legislative matter that they could easily attend to. And I think on that same point, the silence here for 100+ years is not like this is an issue of first impression that maybe slipped the legislature's grasp or attention. These cases have come up before. They certainly could have acted on them, and if they disagree with the result here, they'll act on it again.
Okay, thank you, Mr. Garcia. We will reconvene at 1:15.